Okay, good afternoon everyone. Welcome to the mid-term review of town planning and control. But we're about halfway through the semester, so I thought it'd be a good opportunity to go back over what we've looked at so far and look at what we can move on to next time. Okay, so this week I'd like to take the opportunity to review the first 5 sessions, emphasising some key points. So week 1 provided an overview of the course and the learning outcomes. I emphasise that the focus of the course is the examination of town planning and control, specifically the effect of planning laws upon building surveying functions. This course does not intend to explore the theoretical or philosophical underpinnings of planning theory, but rather examine the planning processes. The rationale for this position is that building surveyors need to understand how planning controls operate, as planning law for certifiers is more about process than outcomes. Urban Planning and Real Estate Development 3rd edition was introduced as the prescribed textbook, necessary as this exam is open book for this course. It was also noted that my comments in relation to Australian planning processes will have a Queensland emphasis, although the assessment questions required students to research planning issues in your states or territories, meaning that the learning outcomes remain relevant for all students. So in session 1 we had a look at a diagram that had a generic outline of the Australian development application process, probably an idealised diagram, but we'd start with preliminary discussions with the planning department. You'd submit your plans reports, council would assess the application and if necessary go for external referral for any advice needed, such as heritage. A report would be prepared by a planning officer. The application would then be assessed under delegate authority or go before a council planning committee meeting. The decision would be made. The application could either be approved or refused, and the appeals could be made on the conditions if it was approved or on the refusal. In Queensland, it's also note that councils can go for external referral agency advice even if there's no statutory referral agency body. They can ask anyone for advice on anything at any time with an application. So Chapter 1 of the textbook provides an overview of the evolution of UK planning laws, with the first identified planning scheme being created by the Housing, Town Planning, etc. Act 1909. Interestingly, Melbourne lots were sold in 1837 and were subject to improvement condition prescribing minimum construction standards. So back in the 1830s there was a form of planning control in Melbourne. So what did planning schemes seek to do? Generally they seek to identify the type of development and then identify the required level of assessment. The type of development may be a physical object such as a new building, which would be an intensification of the site, or a new use, such as outfitting a shop in an existing domestic residence, which would be changing the intensity of the use of the site. Correspondingly, the level of assessment generally reflects the potential impact of the proposed development. In this session we briefly explored the application process, identifying forms of documentation generally required to accompany development application. This documentation includes site details, summary of the existing site environment, summary of the proposed use, and assessment against the planning scheme, details about the zone, the precinct, the area, and how the proposal meets the scheme requirements. A brief reading of pages 33 to 35 of the text provides an overview of appraising development applications, including intangible externalities. Page 41 to 43 has an overview of the application process. So when we talk about intangible externalities, it's a little bit like the carbon tax debate at the moment. There are certain negative or positive impacts that accompany some developments, and they're not always able to be priced into or a price put on them, but they should perhaps be included in the application process. So if you read 33 to 35 of the text, you might get a bit of a picture for what the intangibles are. So when we're looking at other technical reports, other necessary technical reports identified included stormwater management report, traffic impact assessment, landscaping plan, and these will depend on the scope and the size of the development as to whether or not they are required. There wouldn't be any reason why you wouldn't have to provide them if you wanted to. You could provide more than what the minimum standard was, but it may be that the council does require them to assess the development. Additional referral agencies or call-in powers were talked about or looked at. State government agencies may be called in for various reasons. For example, in Queensland, a development application on land within 100 metres of a state-controlled road will require referral to the Department of Main Roads or Transport and Main Roads. Referrals generally involve the applicant sending the application information to the state agency to assess the development. The council, when they send out an acknowledgement notice, would say or would identify who the referral agencies are with the contact details, and you'd send a copy of the development to them for their assessment and comments. State agencies generally have the opportunity to ask for more information and to enforce conditions of approval of the development. So under the Sustainable Planning Act, levels of assessment are exempt development, self-assessable development, code-assessable, impact or prohibited. So there's 5 levels. There used to be 4, but when they rewrote this Integrated Planning Act and created the Sustainable Planning Act, they actually reintroduced prohibited development, which used to be the old column 5 development in the old planning schemes. So now we've got 5 levels. So looking at the levels of development assessment, pages 53 to 56 looks at material considerations, a similar concept to a material change of use under the SPA. The court judgments examined may provide useful reading for students wishing to understand this concept in greater detail. And it is fairly important to understand when something becomes a material change of use and when it is just an ancillary use. There's also a number of court judgments on the Department of Infrastructure Planning website from the Planning and Environment Court that can take you through what a material change of use is. So if people are not sure, it helps to read these and get some idea of the precedents behind the decisions. So we went on to session 4 and we looked at the concept of approvals, who and how appeal, gaming appeals, where competitors will use the planning process as a proxy for anti-competitive behaviour, approval timeframes and relevant periods, conditions, importance of consistency in conditions, reasonable and relevant conditions, and referral agency conditions. Okay, so in order for an approval to have a lapsing date, it must first have a date of commencement. In relation to the SPA, the date of an approval takes effect, the date an approval takes effect will depend upon the following factors. Where there were no submitters or are no submitters, such as code accessible development, and the applicant does not appeal the decision notice, when the decision or negotiated decision notice is given. Where there are submitters, such as impact assessment, and the applicant does not appeal the decision notice, when the submitter's appeal period ends. It may be that the submitters don't intend to appeal, and submitters don't necessarily have to be against the proposal. They can actually be for the proposal and make their submissions supporting it. But without knowing whether or not the submitters are going to appeal, it would be better or probably prudent to wait for the appeal period to end. If there's no appeals made, then the decision notice can be issued. If an appeal is made, when the appeal is decided, which could take a number of months. To accurately determine the length of a currency relevant period, the length of appeal period must be determined. So your currency period or relevant period to do the work is measured from a point in time after the appeals period is finished. Generally, the SPA provides appeal period of 20 business days. In the case of submitters, impact assessment, the following process would normally occur. The MCU approval is posted to the submitters. If no date of evidence is provided as to when they received the MCU decision notice, Section 39A(1)(b) of the Acts Interpretation Act presumes the date of delivery of mail. The submitter appeal period commences 20 business days from that date. or the submitter appeal period ends, that should be 20 business days from the date. Following the expiration of these periods, the development is authorised to start. All development control instruments should contain a time or currency period in which an approval must be completed or substantially commenced. The time period and amount of work needed to occur to prevent an approval lapsing will depend upon the scope and nature of the application. For example, under Section 341 of the Sustainable Planning Act, conditions may impact certifiers in two primary ways: the legality of the certifier conditions and the impact upon certifiers' decision notices of other assessment managers' conditions. So page 57 of the textbook recognises 6 tests that conditions must meet within a UK context. With the Sustainable Planning Act, it does set out in broad terms reasonable and relevant conditions and what can and cannot be put in a condition, but page 57 of the textbook probably gives a bit more information. So the 6 necessary conditions or necessary requirements for a lawful condition are relevance to planning, relevance to the development, enforceability, precision, reasonableness and necessity. So that's similar to what the SPA calls for with a reasonable and relevant condition, but it must also be a condition that can be enforced. It must say who is to enforce it. It must be precise and give definite understanding as to the scope of the condition, and it has to be a necessary condition in relation to the development.